Good morning to everybody, to all my participants who have been listening to this webinar today. And I will be talking on to how to solve your paper. Now, understand one thing, once you get the paper in your hand, it is for 2.5 hours. So 150 minutes you have at your disposal. The moment the paper is given in your hand, my experience tells me people start writing two-line answer, that is question number 1. Never do that. Go to question number 4 first. That is a essay type question where it will have, each question will have 13 marks. Now what you should do for this is, they will give you 5 questions. I am talking related to Mumbai University. They will give you 5 questions in question number 4, say A, B, C, D, E, or 1, 2, 3, 4, 5. Now, on that basis, if you are writing, find out from those 5 questions which answer you know the best. Because the first impression always lasts long. And at the start of the exam, your hand works fast. Now, what you should do, suppose you are choosing question number 4, sub question 3, then give that question 4, question number sub question 3. Don't write just question number 4 1 because you are writing the first time, first question. Because we sit, as an examiner, we sit with our question papers next to us. We see the question is on what. Suppose I am giving an example. Question is on, question number 4 1 is on jurisdiction of the court. And question C is on the review reference revision. Then in that case, suppose you want to write first thing onto a review, revision and reference, then in that case you should give question 4, sub question 3. And then you should start writing. So choose that question first of which you know the answer best. First impression always lasts long. It is a human psychology. Once you have done that, after that, first within 22 minutes, time management is most important. First, each question should not take more than 25 minutes. For example, you write one paper, second, half paper, and your 22 minutes are over. Just leave over there and jump onto the next question onto the new page. Understand this, because out of 150 minutes, if in first 75 minutes your question number 4 is complete with 3 answers, you are safe for this paper. Am I clear? Any difficulty onto this? You can please tell me in case you have got any difficulty. Now, when you are doing this, ensure that your handwriting is legible. Because as the time passes, my experience tells me that your handwriting goes down. We are unable to read. And there is a rule of the university, for illegible handwriting, we need not give marks. So your handwriting should be legible throughout the paper. So after your 75 minutes are over, you should jump on to question number 2, that is the short notes. Now, people ask me, many students ask me, for 13 marks, how many pages we should write? And this is a general question that comes to me from my students over the years. I say I'm not interested in how many pages you write. We are interested in what you write, what are the contents you write, whether the question is on what topic, whether there is a relevance to it, whether you are giving any case laws to it. So that we will see whether the question is relevant, your answer is relevant or not. If your answer is relevant, you will get good marks. If your answer is not, you may lose marks. So that is as simple as that. Then you have to write on to question number 2. For question number 2, what you have to do is, it's a short note. They will give you 4 short notes. You have to write any 2. Now, Again, you will have to choose the best one. Whichever short notes you use, the best note you will have to write. Now it carries 6 marks each. So depending upon the marks allotted to the question, your answer should correspond to that. Your points, the main points you must cover. Because if you don't cover, for example, jurisdiction of the court, what are the 3 criteria that you will take into account? The territorial jurisdiction, the pecuniary jurisdiction, and the subject matter. These 3 things are most important to give a jurisdiction to the court, to the civil court. And that is why you must know on what basis the territorial jurisdiction is given. There are certain cases which give exclusive jurisdiction to a particular court. For example, divorce matter has to go to family court. Understand this. Has to go to family court. The dispute between landlord and tenant, licensor and licensee, has to go to small causes court. Instead of going to small causes court, you go to the city civil court. Because it is a civil dispute, that court will not have a jurisdiction to decide the matter. Even the pecuniary jurisdiction. Today, in a city of Bombay, up to 10 crores, the matters will be heard by city civil court. Again, into that, as far as territorial jurisdiction, from Kulaba to Mahim, it will be the cases will be dealt by city civil court at its main branch in Fort area, whereas from Bandra onwards, they will be dealt at Dindoshi court in Goregaon. So again, that territorial bifurcation has been done by the government. Understand this, you must know which court you have to go, because if the court does not have that jurisdiction, court will return the plaint. And if the plaint is returned, you will have to go to the appropriate court. But in the meantime, if that period goes beyond the period of limitation, your cause of action will go away. Never do that. Even you must know the hierarchy of the courts, right? For example, apex court, that is Supreme Court, then the high courts. Now, there are in India, each state will have one high court, but there are high courts where that high court has the territorial jurisdiction for more than one state. For example, our own Bombay High Court has got the territorial jurisdiction over Maharashtra and Goa, or Punjab and Haryana High Court. See, those states will have additional one more state into under their umbrella, and that is why you must know. Then the district court, then the senior division, lower division, all that junior division, everything you should know the hierarchy of the courts. Now, in addition to that, when you write those 2 questions of your short notes, after that should not take more than 30 minutes. So 75 plus 30 minutes, that comes to 105 minutes out of 150 minutes. So still 45 minutes are in your hand. Now you should jump to question number 3. That question number 3 is the situational problem, where they will give you 4 questions and out of which you have to solve any 2. And at times you will find the answers are hidden in the question itself. Sometimes the second question that is asked will give you the answer for the first question. So you will have to find out that. You have to apply your mind properly over while solving that question. And my experience tells me this one question of situational problem, where application of mind is required, gives you maximum marks. These 2 problems to be solved, 6 marks each. So that is 12 marks. So out of 39 plus 12 plus 12 makes your 63 marks. Now, only the 12 marks. And this question, out of the 45 minutes, should not take more than 15 to 20 minutes. Maximum 20 minutes. So still 25 minutes are in your hand. Now you jump on to question number 1. Why I am telling you should jump on to question number 1 is they will give you 8 questions, you have to solve any 6. But what happens? It is 2 marks. My experience tells me just for 2 marks you want to write not more than 1 or 2 sentences. But students write, let me explain it by giving an example, and that example goes into 2 pages. It's not required. We are not fools to give you 3 marks out of 2. You think the more we explain that concept, we are going to get more marks. It is not so. Because it carries just 2 marks each. One line or not more than 2 lines. And that should not take more than 15 minutes for question number 1. Never try to solve question number 1 first, because it covers the entire syllabus. If you write that question number 1 first, the problem is that, and if you don't get good marks into that question, we as examiner thinks that the candidate doesn't know the subject properly, and it gives a bad impression about the paper. So even if your subsequent answers may be proper, it will affect in giving the marks from our end. So never do that. That question you will have to solve at the end, and still 10 minutes will be in your hand when the warning bell goes. Those 12 minutes, 12 minutes that are in your hand, come back to question number 4 again, where you could not have completed your answer in time. And that is the reason why I tell you, you should always try to solve question number 4 first. Because at the start, your hand works very fast. But as time passes, your writing speed goes down. And the young generation problem is that they do not have the practice of writing. You can type it on your computer or on your laptop. You can be very expert in writing on your mobiles, but when it comes to writing the paper, you find it difficult. So make a practice of writing. You have got 10 days in your hand to start the exam. At least see the papers that are, and let me tell you, in university paper, if you see the previous papers, many questions are repeated. Now, if you take those repeated questions, you will, and if you select those questions, just take one paper, find out whether within 2.5 hours how much you are able to write. So something is remaining balanced. It means your speed of, you may be knowing the paper, you may be knowing the subject, but your writing speed is low, and that will affect your, and that is going to hamper your future education. Maybe you may go for masters, you may go for a foreign university, whatever, wherever you want, it is going to affect your career in future. And that is the reason why you must try. And again, let me tell you, your handwriting must be legible. That is the first thing. I find people putting a margin, sub-margin, writing very nicely. When their presentation of the paper itself is good, they have won half the battle. Their handwriting is superb. Contents, we will see into that. But that good handwriting also goes in our mind. Oh, this handwriting is very good. So instead of giving, say, 7 marks, I may give him 9 marks because his presentation is good. So each and everything you must keep it in mind, and then should write the paper. When the question paper comes in your hand, in first 2 minutes, you scan the paper. Go on to question 4. Again, I'm telling you. Find out which answer you know the best. You might have done good on to Limitation Act. And if the question is there on Limitation Act, go for that question if you know the answer base. Another thing, people write some section number in CPC. You know there are 158 sections, 51 orders, and various rules. It is not absolutely essential for you to know each rule, each section, but remember the important ones. If you are not sure about the section numbers and order numbers, don't write at all. That is because if your that order, that rule or that section is wrong, we come to the conclusion this section also the other section which wrongly he has quoted. Don't do that. Instead of that, just write the papers and keep your mind very cool. Don't come under pressure and write. Oh, I'm lagging behind. Nothing of that sort will happen. Understand that? And that is the reason why you must, once the paper comes, scan it, go to question 4, 75 minutes, then question 2, 30 minutes, then question 3, 15 to 20 minutes, this question 1, 15 minutes, still 10 minutes will be balanced. In that 10 minutes, you can solve the question number 4. Wherever that balance is remain, you can fill up the gap. Am I clear? Anything anybody wants to say, they can ask me the question, then otherwise further I will go.
So one participant in the chat box has written, can you shed light on case laws? How many case laws to cite?
Yeah. Okay. Now the case laws, whatever you know, but the relevant minimum 2 3 case laws you can write, but that should be relevant. Understand that. Give the case law what the court has held. That is what is required. What principle has been laid down in that case. That should be there. For example, in case the question comes on review, what do you mean by review? Going before the same court if there is a calculation error, a error prima facie in the order, in the judgment, you can go for review. Correct? Now, in that case, you will have to go before the same court, before the same judge who has heard the matter. But in High Court, what it may happen that there are two judges, a divisional bench. Two judges have heard the matter, and in High Court, after certain period, the Chief Justice changes the assignments. So one of the judge may go away from here. Suppose he has been transferred to Aurangabad bench. He will not be available in Bombay. In that case, the other judge can hear and can decide on the review. But one of the judge must be there in that hearing of review. What is a reference? When both the sides, the plaintiff side as well as defendant side, present contradictory views, and the judge is confused, which is the correct interpretation, he will stay the proceeding and the court will make a reference to the High Court or High Court to the Supreme Court to give proper interpretation of that particular word or particular sentence that has been quoted. And when that interpretation comes from the High Court or Supreme Court, as the case may be, then in that case only the trial court will take the case further. And revision is always to the higher court. You have to go to the higher court when there is appeal is not permissible. In that case, you have to go for revision. So these three things under section 113, 114, 115 of CPC, you must know. So these are the important sections which you should be aware of. Any more?
Sir, actually, your way of telling the examination is totally 100% right. But one thing I have a query. Our teachers and professors say that write the answers serial wise because the examiner wants it the easy form. The paper answer sheet should be in the serial form. Many a times we are guided like this also.
Payal madam, there is no rule which states of the university that you must write question number 1 first. Now, I don't agree with it. I have been assessing this paper for more than 2 decades. More than 2 decades, I am assessing the papers of the Bombay University. So, I don't agree with the views expressed by my friends because I don't know what is the logic behind it. But then, this is the way in which if you go, you
Yes, sir.
you will get good marks.
Yes, sir. It is a proper time management.
Absolutely, you have correctly said. Proper management has to be there. Time management has to be there for the paper so that you should be able to complete the paper. Now, suppose you start writing question number 1, 2, 3, and lastly 4. By that time, out of those 3 questions, you could write only question 2. So one question has remained 13 marks. So you have attempted 62 marks. And then getting good marks will be a problem. You
Yes, sir.
follow?
Absolutely.
You
Yes.
follow? And because at the time when you start the paper, your hand works fast. And as the time passes, okay, I notice
Yes.
that I notice the people how they do. Okay, they as if they are in the gym. They are putting the hands like this. Their hands are paining and all that. That goes a waste of time. So at that time, at the start, your hand works fast, and that is why you should write question number 4 first time. Question number 4 you must write first. That is
Yes.
what I think. I think there is no hard and fast rule of the university that you must write in the same sequence. It's not that hard and fast rule. But one thing, you cannot do question number 4, one question one place, another question at another place. If you start writing, all those 3 sub questions should be together.
Yes, sir.
Okay? Otherwise,
Yes.
that may irritate the examiner. Oh, we have given the marks over here because then we close on to question number 4. Suppose out of 39, you got 20 marks, and then somewhere at the end of the paper, you have written third answer. Now, that corrections we will have to do, the examiner will get them irritated. And that may affect your third answer marks. So, don't do that. All the 3 questions, sub questions should be written together. All the question number 2, both the short notes be together. Question number 3 is situational problem, both the answers should be together. Question number 1, all 6 should be together. You get me?
Yes, sir. Yes, sir. Thank you very much. I do understand at the end every student is exhausted.
Yes, after 2.5 hours, because you people don't have the habit of writing today. Even I have not written for years together. Well, when I go to the court, I put it onto the computer and take the printout and submit it to the court. Nowadays, so everything online. So because of that, what happens? Our habit of writing has gone. And
Yes, sir.
what do you mean by habit? When you do one thing again and again, it becomes a habit, isn't it?
Yes, sir. Absolutely right, sir.
And you know how this word as habit has come? Which somebody has told me, HABIT, you remove that H, a bit remains. You remove that A, bit remains. Even if you remove that B, still it remains. So you do one thing again and again, it becomes habit. That's why you should start practicing writing now for next 10 days before your exam so that you can get good marks.
Thank you, sir. Thank you, sir. And
Okay?
as the question is one more case laws. When
Yes.
we write case law, we make the three parts facts, issues, and then held, and somewhere
No,
principle also.
no, you write the case law name, okay? Give the
Yeah.
facts in 1 or 2 lines and what was the decision of the court or what principle was laid down in that case by the court.
Okay,
That's
sir.
all. That is what is expected from you. You can't give the entire, the plaintiff has said like that and defendant has said like this in what he has stated in his plaint and what he has defendant has in his written statement. That is absolutely not required. What are the facts of the case?
Okay.
Name facts of the case and what is the decision of the court and in a very shortly.
Yes, sir.
Okay.
Sir, one more confusion we suffer while writing case laws. The years. The years are very difficult to remember.
Don't write unless you are so sure about it. Because
Okay.
here means you are talking about the citations, correct? You are talking about the citation. For example, Maneka Gandhi versus Union of India 1978, so and so Supreme Court and all that. You may not remember the page number also. Don't write anything. Understand this. Don't write the citations if you are not sure about it. Unless you are 100% sure about the section number, order number, rule number. For example, amendment to the plaint. Everybody knows Order 6, Rule 17 talks about amendment. Now, if you are so sure about it, then only you write. If you are not sure, don't write. That's my advice. Now, I have taken 1 or 2 question papers for you to solve. For example, you will be able to find out from the previous papers how the questions are asked. Okay. For example, now attempt any 3 in detail for 39 marks. Now, A was reference review revision, which I have told. Another one, acquisition of rights by prescription under Limitation Act. Now, how a person gets acquires the right by prescription? You must know that, read those Limitation Act. Arrest and attachment before judgment. If the defendant is likely to abscond, and if he thinks that order will go against him, he may abscond. He can be put into civil prison. All that provisions you must read and write. Provision relating to suits by and against the minor. Minor, remember, minor unable to, incompetent to contract, so he cannot file a case personally. He has to file a case to his guardian or next friend. So that is what. Against minor, now if the minor you want to make him a defendant, you have to write a name of that, his age, a minor, through his guardian. Once he becomes major, he will take the call whether to go with the suit or not, whether to defend his stand or not. And such guardian should not have personal interest adverse to the interest of the minor. That line has to come in your answer. He cannot be otherwise a guardian if his interests are contradicting the interest of the minor. That line is must in your answer. So there are certain things which you must know. What is an interpleader suit? Now, what is interpleader suit? Interpleader suit is a real dispute in between the defendants. Plaintiff is not interested. I give you an example. Suppose a building is there where there are 10 tenants in a building, the origin and landlord. Tenants are paying the rent to the landlords every month. Now landlord has expired. He has not made any will. And suppose he has got 2 sons. Each son will say to each tenant, the rent now you should pay me. Now if a person pays to a particular son, other son will object. Now in such case, the tenant will have no interest in the dispute between the brothers, but he will have to file an interpleader suit saying that let court tell us to whom we should make the payment of rent. We are ready to make the payment. And for that, if it goes beyond the 6 months arrears, the tenants will be in trouble. So what they have to do? They will have to approach the court, the small college court in this case. They will have to tell the court that we are ready to deposit the rent in this honorable court. So they are depositing the rent in the court, so they are not in arrears for more than 6 months. So their tenancy cannot go away. This is how they will have to safeguard their interests. Now that is called as interpleader suit. Sometimes they will ask you summary suit or the 37, because what is the difference between a regular suit, ordinary suit and summary suit? In summary suit, the defendant has no right to file his defense unless he obtains the leave of the court. In regular suit, it is the matter of right of the defendant that he shall file the. If he decides not to file defense, court will pass no WS order, no return statement order, and will proceed further in the matter. But as a matter of right in regular suit, defendant has a right to file his defense by way of a return statement. That is not so in a summary suit. So this is one thing I wanted to point out. Then they had asked suit against government, short note. Now when you want to give a against the government, remember under section 80 of Civil Procedure Code, you have to give a 2 months notice to the government. Now you may ask, the government means what? If it is a government, central government or state government, to the secretary of that particular department. Notice has to be addressed to the secretary of that particular department. And if it is a railway, then it is to be addressed to the general manager of that particular railway. For example, general manager Western Railway, general manager Central Railway, whatever is the railway against that, your grievances. But here when you go to the government, 2 months notice has to be given. But there may happen that you may not have a time to approach the government. Because, for example, suppose a municipal corporation has given you a notice saying that the structure that you have constructed is illegal, demolish it within 14 days. Now, in such case, you have no option, because they will come, they will demolish your structure and they will recover the cost of that demolition from you. Now, to save your structure, you will have to rush to the court. You cannot give 2 months notice now to the municipal corporation, because if you give a notice, by that 60 days is over. Before that, they will come and demolish the structure. Nothing survives. So why there is no cause of action, court will say. That is why what you will have to go? You will have to immediately rush to the court and seek injunction. But while filing the suit, you will have to obtain the leave of the court. Tell the court there is a sheer urgency. I have received this notice, and if I give the notice of 60 days, because municipal corporation is also a state under Article 12 of Constitution, and that is why you have to give a notice to the government. But if you fail to give, and if there is sheer urgency, you will have to obtain the leave of the court. Without that, if you don't obtain the leave of the court, which will be recorded by the court in its Roznama, understand that itself the municipal corporation in future will take the advantage. Statutory notice not given, leave of the court not obtained, and hence suit is liable to be dismissed, and you will lose the matter. Never do that. Obtain the leave of the court. Right, clear? Then they had asked adverse possession. When the adverse possession takes place, can anybody tell me when you get adverse possession? Exclusive possession. I am on the word exclusive possession. For more than 12 years, you get an adverse possession continuously for 12 years. But that your possession must be exclusive. Now, if your possession is exclusive, you can get the ownership of that. Now, appointment of receiver. When a court can appoint the receiver, court receiver, his powers and duties. He has to take care of the property if he has been appointed as a court receiver for a particular property. If any taxes are to be paid, he has to pay it in time, and he has to account for whatever money he receives to the court periodically. That is his duty. And if he fails to do that, court can take action against a court receiver. Now the problems we will see. Now sometimes these problems, situational problems, are repeated. Now see, A filed a suit against B for declaration that the religious rites performed by B during the village puja of the deity were not proper. B contends that he has been performing the village puja as per the Hindu religious rites. Is the suit maintainable by a civil court? This is the question. Now, how to perform puja cannot be a civil dispute. Now, another question, whether the right to worship in a temple is a civil right, and is the suit is of civil nature? Yes. To go to the temple and do the prayers, and if the person prohibits over there to you, a civil right. You have a civil right to go to temple, pray over there. But asking a person to perform a puja in a particular way cannot be a civil dispute. So these are the one line answer, two line answer, and you get good mark. This is the one question which will give you out of 12, 10, 11 marks, which will take you to the high scale. And of course, you will have to apply little mind over their application of mind, and you should know the law. X files a suit against Y for recovery of 70 lakhs and serves him the writ of summons, which fixes the date 10th October 25. B has to recover from A 35 lakhs. As Y's advocates, what procedure you will advise? Now this could be, see, one person is asking that I have to recover 70 lakhs. The other person, the defendant, is saying I have to recover 35 lakhs from the plaintiff. So to put either the set off or a counter claim. That will be the answer. In which court can Y recover his claim against X? Now the amount is 70 lakh. So in a city of Bombay, it will go to city civil. It's a civil dispute. Okay. Now, Manish, a minor, wished to sue Dinesh, an adult, pertaining to dispute relating to certain immovable property. Who shall initiate the suit on behalf of Manish? As I have told you, his guardian. Manish attains majority during the pendency of the truth. Can he advise Manish in light of the relevant legal provision? If he wants, he will continue. If he does not want, he will withdraw. See how simple it is. The answers are. Now, as far as the question number one, what is foreign judgment? A judgment given by a foreign court which is not established in India. Simple. What is evasive denials? Specific, it is not denied. That will be evasive. What orders are appealable? Which are not given under Order 43. What is meant by next friend of a minor? He could be anything, but he must be major, a person of a sound mind, and he should not have interest contrary to the interest of the minor. What is execution of decree? Giving the effect to the decree passed by the court. Who is indigent person? Who is unable to pay the court fee and who does not have even 1000 rupees. See, one line. What is letter of request? One court gives a letter to the other, to a court outside India for commission. That is called as when the suit is abated. There are two things you must remember. In case of a family court where the divorce petition is pending, then either the bride or bridegroom expires. Suit will stand abated. Suppose in a regular suit, a right to sue does not survive. Legal errors cannot be brought on record. For example, a trust is there. Some other trustee may come, suit may proceed. But if there are no legal errors, suit will stand abated. What is the effect of part payment on limitation? Now, for example, I take an example of Malvika madam. I have taken 5 lakhs from Malvika madam. I must pay it within a period of 3 years, limitation period. Suppose out of 5 lakhs, I have paid her 3 lakhs and I'm not paying now. Before that 3-year period gets over, I give it in writing to Malvika madam that I owe her rupees 2 lakhs. Then from that date, the when I give that, from that date, she will get a 3-year period to recover that 2 lakhs. So that period gets extended. That is the effect of part payment on of limitation. So these things you must know. Any difficulty? Now another paper I will take, but I will go now in a sequence of question number 1, 2, 3. What is meant by cause of action? Because unless there is a cause of action, you cannot file a suit. So there must be some cause, some right. Your right of plaintiff is infringed by the defendant. Only then cause of action arises. Two duties of court receivers. I have told you to maintain the account, to pay the statutory dues. Okay? What is meant by men's profits? When a person illegally occupies a premises, court comes to the conclusion, for example, the defendant was illegally occupying, the suit is declared in favor of plaintiff. Plaintiff can ask for men's profit. For the last say 10 years, after 10 years, what rent he would have got had he given the premises to somebody else for use. That is called as men's profit. Okay. Now, interpleader suit, I say, what is meant by stay of suit? If suppose stay of suit means could happen on two grounds. Stop the proceeding further till suppose there are one suit is pending in the court. The same party, between the same party, another suit is filed. The second suit will be stayed till the first suit is decided. Or suppose a court makes a reference in a pending suit to the higher court, till that reference is made, the suit will be stayed at, that is order section 10. Okay? What is meant by necessary party? Whose presence is absolutely essential to adjudicate the matter. Now, if necessary party is not joined, the suit is liable to be dismissed. But if it is not so, if it is a question of proper party. So you must know what is the difference between a necessary party and proper party. Now, attachment before judgment. That I have told you how if the defendant is likely to abscond, you can attach also his property, put him into civil prison. Then temporary injunction. Now, as far as temporary injunction is concerned, you have learned this in your first year of Specific Relief Act. That injunction chapter, section 36 to 42. You have learned that, where temporary injunction was granted. Now, temporary injunction, remember, at times can be sanctioned even without hearing the other side. Generally, what happens? Court cannot pass any order without hearing both the sides, and both the sides have been given reasonable opportunity of being heard to uphold the principle of natural justice and fair play. But here what happens? It is not so. Temporary injunction can be granted even without hearing. For example, take the same example which I have given. Municipal corporation has given you a notice. You will rush to the court, ask for the leave of the court, ask for temporary injunction. Let the municipal corporation file his reply. You will have to take a notice of motion and get the temporary injunction. Till the municipal corporation files the reply, my structure should not be demolished. That's all. Court will grant you temporary injunction till next date and will ask you to serve the documents onto municipal corporation. Now, once you serve those paper on municipal corporation, you will have to tell the court by way of affidavit, I have already served onto the municipal corporation. Let municipal corporation file a reply to it. Till they file the reply, the temporary injunction will continue. But if it is given till the next date, on every day, let me repeat, on every day you will have to go to the court and tell whether your matter is called out or not. You will have to tell the court that there is an injunction granted in my favor, it be continued till next date. If you fail to do that, municipal corporation will take advantage. The injunction granted, temporary injunction granted in your favor will stand vacated. And that is why that precaution you as in future advocates will have to take. On every occasion you will have to go. And next question is on commissions. Now, what do you mean by commission? Commissions can be appointed for two. One, for recording of evidence. If the party cannot come due to his physical disability to the court will appoint the commission to record the evidence. At times, the dispute is about the premises, in what condition it is. Then in that case, court will appoint a court commissioner to go and find out and make a report, take the photographs, give the report in what condition the premises is, find out the area of the rooms, which floor, which building, whether it has a lift or not. Everything has to be mentioned by the court commissioner. So these different commissions are appointed for different purposes. That should come in your answer. Now, Akash is aggrieved by the decree of a court. He desires that the same court examines the judgment. What is the re-examination of judgment by the same court known as? Can you tell me? When the matter goes before decree is passed, party is not happy with the decree, he goes again before the same court, before the same judge. Just now I told you what it is called as. Anybody? What it is
Sir, a
called as?
participant has written review.
Yes, absolutely correct. Now, this is called as review. Okay. Now, what is the legal requirement that need to apply in a matter for seeking such a re-examination? You have to make an application for review, and in that you will have to tell where is the mistake. That mistake should be prima facie, on the face of it. Maybe calculation error, typographical error. Such mistakes can be corrected by way of review. Okay, I think under that such mistakes can be corrected under section 152 of CPC. Now again that question which I had given Dinesh ka, that again they have asked repeated. So I tell you these questions are being repeated. Now this question is very for Avinash and Yash are independent businessmen having their offices in India as well as Portugal. With regard to a dispute relating to a business transaction between them, Avinash claims to have a judgment in his favor pronounced by a court in Portugal. In India, what will such court and judgment be referred to? It's a foreign judgment. Mention any three grounds on which Yash can attack the judgment of the Portuguese court in India. Number one, that the court has no jurisdiction, it has not been given on merit, and it violates the international law, public international law. These are the three grounds on which you can say that the judgment can be, I can say, judgment can be attacked. What words they have used here. Now, Jagdish claims title to an easement over certain right of way over the land of his neighbor Rajesh. What must Jagdish prove in the court of law to succeed in a such suit in regard to a right of way? That he has been using it for a particular number of years, that is minimum 20 years. And if it is a government property, then next question is that to what extent does the legal position change where such right of way is over land belonging to the government? Then if it is against the government, then 30 years. Okay. Now explain in detail concept of decree, kinds of decree, preliminary decree, final decree. Okay. Now that question was asked. Then first appeal under, now remember, when you go first appeal is a continuation of a suit. Suit does not come to an end when you go in appeal. So it is a continuation of, but in first appeal, you can always argue on the matter of fact as well as on the point of law. In case of second appeal, it is only the question of law that you will have to argue. So this difference you must know. Then suits by indigent person. How the indigent persons can sued by indigent person means he is a pauper. He does not have the money. He is not able to pay the tax. He is not able to pay the court fee also. He does not have the money. Then in that case, you will have to, it's called as a proper. Now, another paper which I am taking, written statement. Now, written statement, remember, you must write in a regular suit, written statement is a matter of right of the defendant. But in written statement, each averment, submission made by the plaintiff must be dealt with. You cannot make general statement. I hereby, this defendant hereby deny all the allegations made by the plaintiff. Court will say where is the specific denial, and you will lose the matter. So each statement, averment, submission made by the plaintiff in his plain has to be addressed. As far as written statement is concerned, you must be aware of set off and counter claim. Okay, then same thing, appointment of receiver, its powers and duties. See, I tell you, the questions are being repeated. So for last 2-3 years, if you take the question papers and find out what are the common questions are asked, and you now, because of shortage of time, you hamper upon them, you will be able to clear this paper. Jurisdiction and its type. Jurisdiction which? Jurisdiction of the court. So territorial, pecuniary, subject matter. That gives the jurisdiction to the court. Okay. Now this AB has filed a suit against CD. Court has fixed a date for hearing when AB the plaintiff, CD the defendant, and their advocates are present. Mr. CD accepts and admits the suit claim in writing without any dispute or objection in the court. What order will the court pass? AB has filed a suit against CD. Court has fixed a date for hearing when AB the plaintiff, CD the defendant, and their advocate are present in court. It means his advocate is not present. Mr. CD accepts and admits the suit claim. He says, yes, I have to make the payment. In writing without any dispute, court will say, pay him the amount and suit is accordingly disposed of. Can CD later appeal against such order? He cannot. Because once he has accepted that position, he cannot go back and say that I will not do that. Okay. Now, G files a suit against H for specific performance of an agreement for sale of immovable property between them. While this suit is pending, H files another suit against Mr. G for cancellation of the sale agreement. Can the second suit proceed? Second suit, unless the first suit is decided, because the first suit is pending, second suit will be stayed. Understand this? You will have to find out these things. Okay. Now, see, the questions are mainly repeated. For example, appeal, reference, review, revision, creation of ownership by adverse possession under Limitation Act. I told you, by 12 years. Abatement of suit on death of insolvency of the parties to the suit. We have seen suit by and against the government. You have to give a notice. Okay. Summary suits. Order 37, where the defendant has no right to file his return statement as a matter of right, but he can file his defense with the approval of the court after taking the leave of the court. And decree, types of decree. You have to give what do you mean by decree? Its meaning, types of decree, preliminary, final decree, and execution of decree. How the, and let me tell you, getting an order from the court, executing is very difficult. If you are unable to execute the decree that court has granted in your favor, understand that it will become a paper decree. What's the use of that order of the court which grant you order in your favor if you are not able to get the fruit of that decree passed by the court in your favor? So getting an order from the court is an easy task. Executing is very difficult. Now with that, I think in case any student has to ask any questions, they can ask me.
Sir, a participant is asking, according to you, which author is the best for CPC?
Tekwani. Read
Okay, sir.
Tekwani or Mullah. A small book edition comes from Mullah. Indian practice by Mullah.
Okay, sir. So the next question is, from the Limitation Acts, what according to you are important provisions that we should not miss?
Now see, as far as adverse possession or this part payment, these provision you better read, because generally those questions are asked onto that in Limitation Act. Okay.
Okay, sir. The next question, in case I go through question number 1 and I know all the answers beautifully, so should I attempt question number one or no?
I will not recommend that. I will not recommend that, because question number 4 is always better to write first, because your, as I told you earlier, your hand works fast at the start, and since the, even if you know the answers well, all the answers well of question number 1, okay, you all know, but then you may not get the time to do justice to your question 4 answer, which is carrying 13 marks each. So it is better always to write question number 4 first, then move on to question 2, then on to question 3, and then lastly to question 1.
Okay, sir. So next question, should we leave lines between paragraph for better presentation?
Not necessary, because it will amount to that you want to just to fill up the pages. Don't do that. Take a new question on a new page. Huh? New question on a new page. Yes.
Okay, sir. So next question, should we use black ink? Does it make any difference?
So it is better you use the black ball pen, because what happens nowadays universities, you know, they scan the paper, and when it is written by black pen, black ball pen, okay, it is very clearly we can see on the screen, and we can read the answer, and we can give the. So it is better to use the black ball pen.
Okay. The participant who asked this, it will be of help to others. So participants, please make a note of this. Use a black ball pen. So last question.
Yeah.
Do use of supplements irritate the examiner at times?
Very good question. It is inversely proportion, in the sense, the more the supplements, okay, the candidate generally, because we give nearly 40 pages. Remember, the main answer sheet is of nearly 40 pages, and in 3 hours, writing 40 pages is a difficult task. So, if you are taking, after writing 40 pages, if you are taking again the supplement, it means you are not, generally, yeah, it's not a hard and fast rule, but generally you are not thorough with your studies. That's why you are just filling up the pages, and that may affect your marks. May. I will not say it shall, but it may. Unless you are You know entire thing very thoroughly and you write. Exceptionally good, yes. And we read each and every page. Huh? Let me tell you. Even if by mistake, even if our one page remains, computer does not allow us to submit the paper. So there is no chance that we have not checked the entire paper.
Okay, sir.
Okay.
So, sir, can we wrap up?
Yeah, and I hope the students have got something to learn from me. They said I will be very happy if they give the feedback to madam, and madam sends the feedback to me, so that I believe after so many years of teaching that every person should have a chance to improve further. So if all the participants can send their feedback to madam, I will be very happy. So
So
that's
from my side, I can say that it was a very, very, very informative session. We got to in the Q&A also the questions that were asked, and we got to learn so much from your session. Thank you so much, sir, for sharing your expertise with us. It was very beneficial. Thank you, sir.
thank you.